N.H.K versus A.J.K. For those of you following along, you can find it in page 119 of your bundle and page 6 of your summaries. We are staying with N.H.K in the Pretoria High Court. This one's Safley citation ZAGP PHC 141, and that is N.H.K versus A.J.K. Now, what was interesting in N.H.K versus A.J.K is that the applicant approached the court and essentially said, I want to move out of the matrimonial home, and set out that it is intolerable for her to remain in the matrimonial home. She sought interim spousal maintenance, medical aid, contribution towards legal costs, and living expenses pending outcome of the divorce. Parties were married for 45 years, living separately in the same house, and obviously on the part of the applicant, there were allegations of intolerable conditions. The court considered the standard of living of the parties during the marriage, applicants' reasonable requirements, and the respondent's income. It looked at the fact the old established principle an applicant's claim should be reasonable and supported by moderate details. And it obviously also looks at the responsibility of the husband to look at a contribution to costs. First off, folks, the court did make an order, spousal maintenance, 15,000 Rand per month, maintaining the applicant on medical aid, and a contribution of 100,000 Rand towards legal costs in installments of 10,000 Rand effective from 29 February 2024. So if you have a Rule 43 claim that you are bring it in Pretoria, and if you're defending it, try and have it heard in Bloemfontein, because obviously the cost contributions in Pretoria are somewhat more substantial, one would say, than the ones that we've seen in Bloemfontein so far. First up, I've put in paragraph 31, which is just a cautionary tale, and we're seeing it quite a lot these days, unfortunately. Courts being troubled with a paucity of relevant information. The parties' FDFs provide very scant information. Be very careful if you are practicing in Gauteng to ensure that your financial disclosure form is properly and thoroughly completed, or you may end up having some difficulty in court and frustrating the court in terms of making heads or tails of what is going on the papers. And then in respect of the intended relocation, this is something I know that pops up in some Rule 43s. Interesting things said by the judge in terms of the relocation, which I've put in here. Paragraph 37, the court essentially found that the proposed relocation and the attendant cost seem unsupported by evidence on the current facts submitted. And then in reaction to applicants' allegations that the parties had not lived together as husband and wife since 2015, respondent highlights that it is 8 years later now that the applicant alleges that it is intolerable to live in the same house with the respondent. He denies any form of abuse. Obviously, the old question arising, as it arises very frequently in divorce matters where allegations of abuse come out. Why now? Why is it intolerable now? Why wasn't it intolerable 8 years ago? So obviously, if you are dealing with matters where there is an envisaged relocation on the basis of alleged abuse, be very careful to set out the full facts relating to the envisaged relocation, why it is intolerable, and give the court chapter and verse. That was N.H.K versus A.J.K, Pretoria High Court, and our Safley reference ZAGP PHC 141.